I'm Frank Peel. Thank you for joining me today with another session of In Geneva, in Conversation with Frank Peel. We're going to talk today to a distinguished lawyer, and we're going to talk about genocide, about law, international law. But before we start, just a couple of words about why we have the subject we have. Most of us in Europe and in North America and other parts of the world, if we get attacked by our government or by other people or something like that, we don't even think about it. We have recourse. We have courts to go to. We have machinery which redresses the damage which is done. It may take a long time, but it happens. Now, in the case of many people in many parts of the world, there is no national court system. There is no redress possibility. So this has become a subject of international law, a subject to which the international community has decided we need to focus. My guest today is an American lawyer who is the president of the UN Tribunal on Humanitarian Crimes in Yugoslavia, and also with reference to Rwanda. Welcome to the show, Judge Gabrielle McDonald.
Thank you.
Now, I'd like to start by referring to a book which came out last month, which is called Judging War Criminals. We're very lucky in Geneva because we have two people, maybe more, two people who are active in the international community who were in fact part of the staff at the Nuremberg war trials 50 years ago at the end of the Second World War. There is the American, of course, Maurice Abram, and there is the French Dr. Yves Begbedaer, who's had a distinguished career at the World Health Organization, and who wrote this small book which came out last month, and which The Economist said is the best short book on the subject. It's very readable, it's very complete. I recommend strongly that you go out and read it, because it's the simplest and best way to understand what's going on here. This is a process which is going on, which is a long process, and Judge McDonald is going to tell us about it and about herself. Now, I'd just like to start by reading a few words from the introduction to this book. The introduction is by Theo van Boven, who also, of course, was in Geneva as the director of the Human Rights Department of the United Nations. But he perhaps was a little bit too active in what he was doing. He believed that he had work to do, and the result was he did not get but renewed by Kurt Waldheim at the end of Theo's term. In the foreword to the book, Theo talks about what we're talking about here being at the borders of hope and desire, despair. At the other end of the spectrum, the dark side of the spectrum is filled with accounts of man's inhumanity, and we see that every day on television, to man, and the apparent failure on the part of the international community to prevent, to counteract, and to restore. Yet at the other end of the spectrum, significant glimpses of hope are on the horizon. Women and men live and act in the belief that the forces of evil and destruction should not be allowed to prevail, and instead that respect for human dignity and for a just society should be the standard of conduct and achievement. Judge McDonald is one of the leaders in this struggle. Judge McDonald, tell us a little bit about the court, the tribunal that you had, and the way it works, why it was set up. We'll talk about you a little bit later, but could we start by, could you tell us a little bit about the tribunal, its beginnings, and how it works?
Well, first of all, the name of the tribunal is a very long name. It's the International Tribunal for the Prosecution of Persons Charged with Serious Violations of International Humanitarian Law in the former Yugoslavia since 1991. One of the first tasks of the judges when we met in 1993 was to shorten the name, and so we now refer to ourselves as the International Criminal Tribunal for the former Yugoslavia. And as you indicated, there is also a tribunal for Rwanda, and that's the International Criminal Tribunal for Rwanda. Our tribunal, the Yugoslav Tribunal, was established in 1993 by a Security Council resolution. It was established because there was a determination that was made by the Security Council through a series of resolutions that there were serious violations of international humanitarian law going on in the former Yugoslavia. Murders, ethnic cleansing, rapes, systematic rapes. And it was their decision that a court would help to bring about international peace and security, that by prosecuting persons, individuals, and holding individuals accountable, that we would help to bring about peace. So we were established by a Security Council resolution in May of 1993. Judges were elected by the General Assembly, and we came to The Hague in November of 1993. And at that time we had no premises, we had no rules, we had no courtrooms. We sat around a table in the Peace Palace and discussed how we would create, how we would develop, really, this court.
But you had none of the facilities, but you had plenty of work to do, plenty of examples of man's inhumanity to man at that time. One other thing that Yves Begbader refers to in his book is precisely the circumstances at the time. And he says that essentially the birth of the court, the birth of the tribunal, was really a double alibi by the international community because of the failure of the international community, in particular the United States and the European powers, to react to the ethnic cleansing that was going on at that time. And he says, Begbader says that this was the first part of the alibi was to turn to the UN for humanitarian relief in the area. And the second part of the alibi was the establishment of the tribunal. Reading this, hearing this, one has a terrible sense of déjà vu, that this is what we're seeing again now, 6 years later. But now the tribunal exists. Do you feel that this was part of the birth of the tribunal, the surrounding circumstances?
The alibi, well, I've certainly heard that from a number of sources, and the feeling was that the international community as a whole was either not willing or not able, what I've heard is just not willing to become involved in the conflict in the Balkans, and that they decided that they would do something, and so they established the tribunal. And it is sometimes said that there was an expectation that the tribunal would not function, would not be able to get off of the ground. In fact, when we first began, and I came here in November of 1993, as I indicated, we didn't have a budget, and we did not have a budget for a calendar year until 1997. And so in the early years, I say early years, but this has really been a very short time. If you think about the development of a national judicial system, it takes hundreds of years. But still, in the very early years, we didn't have a budget, and as I indicated, we had no premises. What we had was the statute that created us, with the chambers, 11 judges, a prosecutor as a separate organ, and a registrar. And as a matter of fact, Theo van Boven was our first registrar. So I know him and I respect him very much. Regardless of why we were established, whether it was an alibi or whether it was a genuine effort to help to bring about peace, the fact is that we were established. And the fact is that we did overcome the obstacles that we faced, so that now we are fully functioning, and I perhaps can tell you about that later in the program. But as it relates to Kosovo, it's in a sense sort of the flip side of the coin in a way, in that when we were first established, it was thought that by some, that we would not succeed, and perhaps some did not want us to succeed. Now what I have seen with respect to the Kosovo conflict is that the tribunal has been thrust into the spotlight, and by some have really been, we have been treated as if we are the be-all and end-all solution. And so that's
the alibi,
yeah.
perhaps.
So that's very curious. But you see, it's a different approach. First, it was, well, we will create, so some thought, a tribunal, not properly funded, without facilities. Now that we're fully functioning, there is a concern of, well, how do we end this conflict? How do we bring about peace? How do we end this horrible humanitarian crisis? And what we hear is the tribunal being mentioned constantly. Now, that is unrealistic because no court can stop a war. What we can do is to create conditions to help to bring about peace and reconciliation. So my point is that we're being viewed differently, but in a sense we're still being thrust to the forefront as a solution.
Let's just go back just a wee bit here, because you said earlier on that there were some who thought that the tribunal would not function, or would function in a perfunctory way in the beginning. And now again you've said that there are some who are perhaps surprised that the tribunal is functioning. Did you feel any pressure at the early stages just to go through the motions and not really set up a serious tribunal?
No.
And the second part of that is that have there been any attempts made to reduce the scope of the tribunal, for example, by keeping its budget down to less than you really need?
Well, in the beginning, I didn't feel any pressures. The problem that we had, as I indicated, is that we had budgetary problems, so that we didn't receive a budget. Instead, we received allotments, sort of like you give your children, you give them an allowance and you tell them don't spend it all in one place. So we received usually quarterly allotments, and that seriously affected our ability to function. Of course, we were funded by the United Nations, but it's from the General Assembly, and it was a Security Council that established us. And some have said that there was tension between the Security Council and the General Assembly. Some in the General Assembly, or some states, believing that it was the General Assembly that should have established the tribunal, or perhaps by a treaty. So I don't know whether our failure to receive regular budgetary funding was because of a lack of interest in the tribunal, or political will for the tribunal to succeed, or whether perhaps in part it was just that tension between the Security Council and the General Assembly.
To go back to your analogy about an allowance, a periodic allowance for children, children are generally given at least some hint about what they should do with the money. Were you brought under any pressure, or any hints, any nudges, any winks about what you should do or what you shouldn't do with the money, or did you have the kind of judicial independence that you clearly need?
We had that in the beginning. And I speak for myself as a judge, and I can speak for the judges with whom I am friendly, and I know of no judges who have faced any pressures from their government. But certainly for me, I've never faced any kind of pressure from my government to act in a certain way. I was a judge before I came to this tribunal, and I take my oath very, very seriously. So there was never any pressure put upon me. One of the major proponents, of course, of the tribunal was Madeleine Albright, who at that time was the permanent representative at the United Nations from the United States. And she has continued to be a strong proponent of the tribunal. But being a proponent does not mean that you control the judges. That is something that has never happened in my experience, or even an attempt to control the judges.
Because you have the Security Council, which is in a sense your parent body in many ways, and the Security Council, of course, has the 5 major powers with a veto. And so if, for example, Mrs. Robinson's suggestion, the suggestion of the High Commissioner for Refugees, for Human Rights, if her suggestion that maybe the tribunal should look into the question of whether the actions of NATO, the 19 countries that make up NATO, whether those actions are something that might possibly, just possibly, constitute indictable matters for the tribunal. What would the what would happen under those conditions? Would you speculate a little bit that if this does go further, if this whole question of maybe it started already, I don't know, maybe the tribunal has taken up this suggestion that the actions of NATO, or the 19 countries that make up NATO, those actions are something which might fall under the terms of reference of the tribunal?
Well, as I indicated, there are 3 separate organs in the tribunal: the chambers, the office of the prosecutor, and the registry. The prosecutor is an independent organ, separate and independent, and so her responsibility is to investigate crimes, alleged crimes, that fall within our jurisdiction. And as a judge, I do not have a part in that process until an indictment is prepared and is then presented to a judge for confirmation. I am president, I preside over the appeals chamber, so actually it would be presented to a member of a trial chamber. So that's a determination that would have to be made by the prosecutor. She, under the statute, conducts investigations and then, as I indicated, issues an indictment. Our subject matter jurisdiction and personal jurisdiction and temporal jurisdiction covers all persons who are charged with the commission of serious violations of international humanitarian law in the former Yugoslavia. So there are no exclusions. And so that definition speaks for itself. What the prosecutor is doing, what her plans are, I really cannot, I just don't know, and it certainly wouldn't speculate.
You probably wouldn't want to know what she's doing, but she also, if I'm not mistaken, is designated by the Security Council, or by the Secretary General, perhaps, and with the Security Council presumably very conscious of the fact that this person, prosecutor, the present one, or future prosecutor, may, under the present terms of the tribunal, may move against one of the 19 NATO powers, or may move against individuals who might fall under the terms of the statute.
And that's something that the prosecutor would have to be concerned with. She is independent, she's competent, and I believe that she will do her job. As far as the concerns of members of the Security Council regarding this matter, once again, I simply have no information. Sometimes I feel as a judge as if I'm a catcher in American baseball. I'm not the pitcher. The prosecutor initiates the investigations, issues the indictments, and then the judges confirm them. So what pressures she might be under, I just don't know.
Well, Judge McDonald, let's stay with that figure of speech, and let's take time out for a minute before we come back to talk about you yourself.
That Tadic was involved in.
Perhaps one would have liked to know what were the significant facts in the German jurisdiction which raised these allegations or suspicions.
Ich betone erneut und mit Nachdruck, dass dies in keiner Weise ein Hinderungsgrund.
The interplay between the various potential perpetrators becomes a matter of considerable importance.
President, my friend Mr. Blewett has pointed out that there was one further question that Your Honour, Judge Jordan, put.
Immunity of heads of state, leaders and principal planners of the crime of genocide, wherever they may be located, and regardless of their official position at the time they committed the crimes, will be brought to justice.
Now that we've seen a few shots of the court, of the way it operates, and now we're going to come back and we're going to talk about the President, Judge McDonald, the President of the court. Judge McDonald, tell us a little bit about yourself. We've talked up to now about the court, the tribunal, about what it does, about the broader implications. It's no accident that you're here. Tell us a little bit about your own career and about your own motivations.
Well, in terms of whether it's an accident, I don't know. I imagine there are dozens or maybe hundreds of lawyers in the United States who are just as competent as I am. But the State Department the United States submitted my name for the position of judge with the tribunal. My background, I've been a lawyer 33 years, I believe, so I don't need to tell you everything. I don't think the program is long enough. But I went to law school, Howard University, and I applied to one law school, and that was Howard. And that was during the 1960s. I graduated in 1966. And that was during a very difficult time in the United States, a turbulent time for civil rights. The Civil Rights Act of 1964 became effective in 1965, but I went to Howard because I was concerned about civil rights, and I wanted to be a civil rights lawyer. And
why Howard particularly? Howard is a special university. Special background.
Howard at that time was, and its history, was a think tank almost for the civil rights movement. Thurgood Marshall, Charles Hamilton Houston, many of the major leaders in the civil rights movement would come to Howard and practice the arguments before the faculty and students that they would later present to the Supreme Court.
Howard, for our audience, I think we should tell them that Howard is in Washington.
Yes.
And people like Thurgood Marshall and the other names you mentioned were people who were leaders in the Afro-American community in the struggle, in the fight, the civil rights struggle in the 60s.
Yes.
And you became part of that group of leaders. What did you do after Howard University?
Well, after Howard, I joined the NAACP Legal Defense and Educational Fund.
National Association for the Advancement of Colored People.
Well, it's not the National Association for the Advancement of Colored People. That's a separate organization, but the NAACP Legal Defense and Educational Fund was an organization devoted to the legal aspects of the civil rights movement. Thurgood Marshall had been the director counsel of the Legal Defense Fund. Jack Greenberg was the director counsel when I joined. Thurgood Marshall had left.
Thurgood Marshall also became a member of the Supreme Court. I think for our audience who are 90% non-American, I think we need to spell out a little bit who they are.
Thurgood Marshall had been the director counsel, and then Jack Greenberg was the director counsel when I was there, and you're correct. Thurgood Marshall went on to become a judge on the Court of Appeals, and from then, of course, he became an associate justice with the United States Supreme Court, the first African American to be a member of the United States Supreme Court. So I was fortunate enough to join the Legal Defense Fund, and the organization was really the premier civil rights legal organization. And I traveled throughout the South, through in Alabama, Georgia, Louisiana, and Texas. I married a Texan eventually and moved to Texas, representing persons primarily in employment discrimination cases, persons who were denied their equal rights under the Civil Rights Act of 1964. And then I moved to Texas, and I continued to handle civil rights cases for several years, and I was then appointed by President Jimmy Carter of the United States to the Federal District Court in Houston, Texas. And we had over 1,000 federal judges at that time, and I was the third African American woman who had ever held a position as a judge with the federal courts. I remained a federal judge for about 9 years, and then I left and I went into practice, joined a firm and practiced for a while, and then taught law, which I really enjoy doing. And my plan was to teach law for the rest of my career.
And then along came the international field.
And then along came the International Criminal Tribunal. I received a call from the legal advisor
of the State Department.
For the State Department of the United States, and asked me if I was interested in being a judge with the tribunal. And I said, what tribunal? Because unfortunately there wasn't much news being received about those efforts. So he explained it to me and sent me a copy of the statute, and I then sent him my resume, and I didn't really think that anything would come of it because I had planned to teach at another law school as a distinguished visiting professor. And he then contacted me later and told me that I was one of 2 people who were being considered, and then I was then advised that my name would be submitted, and it was submitted, and I was elected by the General Assembly, received the highest number of votes, and that was in 1993, and then I was re-elected again in 1997 for a second 4-year term.
And you became the president.
Then I became the president in November of 1997, which is a 2-year term. I'm a mother of 2 children. My son is in his 2nd year, well, he's completed his 2nd year of law school at Georgetown in Washington, and he'll be working with Werner Lipford, a law firm in Washington, D.C. And my daughter is an aspiring screenwriter in Los Angeles, and I don't know what else you would like to know. Most of the articles that I see about myself begin with Judge Gabrielle McDonald, age, and then they list my age, which is 57 now. As a matter of fact, there was one article that was written.
I didn't ask you.
I know,
I
but
didn't ask you.
It was written on my birthday, and it began. This was last year. Judge McDonald, who turns 56 today, and then they go on to talk about.
I didn't ask you, Judge, but I must say, because it's true, that you don't look it.
No, well, thank you.
So that brings us right up to date. Now, you've told me that you're not going to be staying on the court after the end of your term as president, which I think comes in November of this year. What are you going to do after that? Your career, it seems to me, your life's journey seems to have been of a piece, that you've followed a number of straight lines about doing things which are in the direction of bringing law to people who don't have law. Is that a fair way of describing it?
Well, that is. I've never thought of it that way, and I think you described it very eloquently, much better than I've described my own life. I've never been a person who has basically planned what I was going to do. I became involved in civil rights, and I followed that through. The international law bug, I suppose, has bitten me, and I was residing in Houston, Texas, but I will be returning to New York City, where I grew up, and am interested in arbitration. I did arbitration and mediation before I joined the tribunal, and so my goal is to continue to work in the international law field.
Why have you picked New York? Why don't you come to Geneva? Geneva is also a center of international law and arbitration.
I'm a member of the New York Bar.
So am I. I'm doing fine in Geneva.
Well, that's a possibility. All options are open, but I really miss the United States. And I've been away now 6 years, and when I was elected president, I told the judges I would serve for 1 term. So I think it's time for me to go home, and that's what I'm interested in doing. You know, I like to see a resolution of disputes. As a judge, of course, we resolve disputes, but we resolve them in a different way. It's after the fact very often. There must be a way, it seems to me, particularly if we talk about conflicts, ethnic conflicts, there must be a way to get in the beginning, perhaps, before they reach the horrendous level that we've seen them reach in this century. So I will continue to speak about the tribunal. I have told my fellow judges, and indeed I wrote a letter to the staff of the entire staff. We now have almost 750 people, telling them what I believe in my heart, and that is I will not leave my belief and my love and my care about the tribunal when I leave The Hague. I will take it with me, and I will continue to speak out about the tribunal. And I've done that, and now living in the States, I'll be able to do it without traveling across the ocean. I'll be right there.
Well, we have a direct flight between Geneva and New York. You'll have to come to Geneva. But you talked about resolving conflicts among ethnic groups, perhaps before they start. but your arbitration activities are not going to be in that field quite.
Well, not necessarily.
If you
you
want
know, you
this-
can do arbitration. You can do private, or public mediation, conciliation. There are a number of ways that you can handle its alternative dispute resolution. Basically, that's what it is, an alternative to the court system. So that's what I'm concerned about, really. My plans certainly are not firm. I really don't have a lot of time to spend at this point.
I'm sure you're not going to have
firm.
any trouble finding all kinds of interesting things to do.
Well, I have some options that I'm considering now, but it's just a question of having the time to sit down and really look at what I have before me and whether it fits with what I want to do.
Well, I just want you to promise me that you won't forget Geneva, that's all.
Oh, I
in
certainly
all
won't.
this.
Geneva's lovely. I've been there.
We'll get you back there.
Okay.
Now, let's finish up. Let's finish up by trying to see what this is all about and where we're going with all this. And are we going back to what Theo van Boven said, between hope and despair? Do we have reasons for hope in the process of bringing law to everybody, or at least to more people? And if so, how long is it going to take? Why are we seeing in Kosovo now a repetition of what we saw before the tribunal was set up, and in response to which the tribunal was set up? The tribunal hasn't stopped this. Neither has the bombing.
I'm glad that you said that. Well, the tribunal is not the only solution. There are diplomatic, there are military, there are a number of avenues that should be explored. I am an optimistic person, so I believe that there is hope. This is a very difficult time for me, however, because that hope, that belief in hope, if that's the appropriate way to put it, is being tested. It truly is being tested, because what we're seeing now in Kosovo, we at the tribunal were aware, at least, that there were major, major problems. In the last several months, I have addressed the Security Council twice. I have written to the Security Council 4 times reporting non-compliance of the Federal Republic of Yugoslavia with respect to the execution of arrest warrants, with respect to the refusal to grant visas to the prosecutor to enter Kosovo, with respect to the denial of the prosecutor herself entrance to Kosovo. And so I've done a number of other, taken a number of other actions in this respect too. So we've been aware of the situation. We have attempted at the tribunal to do our part to bring this to the Security Council.
And what is the reaction? Because what you're talking about is, it goes beyond the question of crimes committed by the Federal Republic, i.e. Mr. Milosevic, but also obstruction of justice, really, in terms of non-access, in terms of no visas, non-cooperation, and so on. What's the answer? The answer, it seems to me, is both on substance, both on the crimes themselves and on obstruction of justice. The answer is indict Mr. Milosevic.
Well, once again, that's not my responsibility, and as a judge, I would never speak in terms of crimes being committed by any individual until that person has been indicted, and then even after a person has been indicted, the person does have that presumption of innocence, and until
Despite all the evidence to the contrary.
Yes. Well, I'm a judge, and I'm president of the tribunal, and I make decisions within the framework of law.
But you were the person who addressed the Security Council on this, not the prosecutor.
And I addressed the Security Council to report non-compliance with our requests and our orders. And so in that respect, the Federal Republic of Yugoslavia was failing to meet its obligations under international law, failing to meet its obligations with respect to the UN Charter, because we were established as a Chapter 7 mechanism, which imposes a mandatory obligation on states to comply. So I reported that non-compliance. The Security Council has issued one resolution after one of my addresses, but when I last addressed them, when I last sent them a letter, I was bringing to the attention of the Security Council the non-compliance because of the failure to allow the prosecutor to enter Kosovo, and I have not heard a response. I have not received a response.
No response whatsoever?
Not from that last communication.
How long ago was that?
That would have been in probably February.
February, and here we are in June. That's quite a number of months for non-response to such a question.
It related to the prosecutor's refusal to the refusal of the Federal Republic of Yugoslavia to allow her to enter Kosovo in January, as I recall, and I reported the non-compliance shortly thereafter. If it wasn't February, it was March.
So doesn't that really bring us to one of the points here, which is that so much depends on political will, not judicial procedure. Security Council means political will, I suppose.
They operate very much in tandem, because the tribunal does not have an enforcement agency. We rely upon states to execute arrest warrants, and when there is non-compliance, as I indicated, we rely upon the Security Council to determine what are the appropriate measures to bring about compliance, because we do not have what national systems typically have.
Right. Now, I don't want to end on that negative note, because you did say that this was a moment when perhaps hope was a little less.
No, well, it's being tested. My hope is being tested.
It's being tested. So what's your conclusion for the long term? If you can step aside, put yourself into your future non-judicial role, and try to sum up your experience and what hope it perhaps holds for the future, and if so, how long is that future before we really begin to see the kind of international structures that we take for granted in our domestic?
Well, we have, of course, the Permanent International Criminal Court, the Rome Treaty that was established last summer, I suppose it was, in June. Am I losing my years? No, it was in the summer of last year, in June. And 120 states at least signed on to the statute. So that indicates to me that there is some hope, and because that would be a permanent mechanism to address violations of criminal violations of international law before the conflict reaches, hopefully, the magnitude that it reached in the former Yugoslavia. We were established after the conflict was ongoing. Here we'll have an international court that will be in existence before conflicts occur. And that's helpful, it seems to me. Perhaps that will be a deterring factor. But that's way down the line somewhere, yes.
And no U.S. either.
And no U.S. at this point, that's for sure. But the other countries went ahead anyway.
Do you think the U.S. will come around to seeing?
I don't know. I really don't know.
When you put your efforts to that cause?
Maybe so. I don't think I have that much power, but I certainly will speak out on behalf. I have spoken to the Preparatory Commission for the ICC, and I will address the Preparatory Commission again in New York, probably in July. And I'm very interested, obviously, and committed to the process of using the rule of law to help to bring about a civil society. That is what separates us from those who use self-help, which escalates into absolutely a horrendous situation.
Judge McDonald, thank you very much for that extremely interesting talk.
You're quite
and
welcome.
We look forward to having you come to Geneva in a few months to tell us more of the same story. Thank you very much indeed.
You're quite welcome.
This is Frank Peel. That's the end of my last show before the summer. Now, we have a special program for you in the summer. We have reruns of two of my shows that you've liked best. The first, which is on the Friday, the 2nd of July, Friday the 2nd of July, my guest will be Phil Collins. It's a rerun of my successful show with Phil, Friday the 2nd of July at 9:15. Then the next part of the summer schedule is in August, on the 6th of August, again Friday at 9:15 in the evening, where we'll do a rerun of my show with Madeleine Kunin, the Swiss-born American ambassador, who at that point in August will in fact be leaving Switzerland to go back to the United States, to the regret of everybody in the international community and to the regret of most, but not all, Swiss. That's the end of my show for today, the end of this season. Thank you very much for joining me. Thank you very much, Nathalie and Jean-Jacques. Good night and bonne continuation.